Poor old PC Mark Knights. Sorry, I meant former PC Knights. What a journey he's been on. For the past year I've been chasing him tirelessly through the courts to have him prosecuted for headbutting a member of the public. A member of the public who did nothing more than take offence to being called a fat cunt by the officer. PC Knights was found guilty in court for common assault late last year. Now he has finally been brought before a misconduct panel at Derbyshire HQ to find out if he could keep his job. Throughout the hearing, PC Knights was unrepentant. Despite his criminal conviction, he was adamant that the headbutt was reasonable self-defence towards someone who asked him to apologise, which leads me to wonder how many other innocent people PC Knights headbutted during his career. We will never know, because the misconduct panel didn't buy Knight's pathetic lies and went and gave him the sack. Oh dear, what a shame. When I heard about it, tears were rolling down my face. It was that funny. Oh well, bite in. Don't slam the door in your face on the way out. Next! PC Buckle and PC Cotton. That duo of defective policing who bullied and threatened a teenager for crossing a road because they were bored and wanted to inflict the torment of being themselves upon somebody else. In August, and with the say-so of the victim, I initiated a private prosecution against both officers for using threatening and abusive words and behaviour under Section 5 of the Public Order Act, and in the case of Lauren Buckle, careless driving. The same type of offences the police bring every day against drivers who engage in acts of road rage as these two did. I also added the common law offence of false imprisonment to the list because when an officer detains you under threat of arrest for a made-up offence simply because he's taken a dislike to you, it is false imprisonment at both criminal and civil law. Now, I knew this one was going to be a challenge because public order offences are relatively trivial compared to the violent offending of someone like PC Knights, but the police jam the courts to bursting every week with prosecutions for public order offences against the public, and often for behaviour far less offensive than Cotton and Buckles. If we the public are expected to behave ourselves to a standard dictated by the state, then shouldn't the police be held to the same standard? Short answer, no. Not according to the lower courts anyway, who take the view that the police may detain us, insult us, swear at us, threaten us and abuse us, even when we haven't committed any offence, because that is, to use the judge's words, robust policing. It might well be regarded as robust by authoritarians, but that doesn't make it legal. Because if it does, that means the police are held to a very different standard of law than the rest of us. I also predicted that the police would roll out the big guns for this one, because there is no way that they want a member of the public prosecuting the police for the same public order offences they prosecute us for, and they were going to do whatever it took to stop me. So the National Police Chiefs Council employed a firm of solicitors at £217 an hour and a barrister at £500 an hour, just to ensure that Cotton and Buckle would not be summoned and I wouldn't dare prosecute police officers again. The night before the hearing, Staffordshire Police's legal department sent me an inflated costs breakdown, insisting that they would seek to reclaim it in full from me if the summons was refused. I took the emails as they were intended, a crude attempt to bludgeon me into submission with the threat of costs. The criminal procedure rules make it clear that costs can only be recovered where there's been an abusive process on the part of the prosecutor. But Staffordshire Police seem to believe that just because the proposed defendant was a cop, it was an abusive process. And they further argued that if the summons was denied, that would automatically mean my prosecution was an abusive process. An absurd argument where Staffordshire Police failed to cite a single precedent which supported such a malign view. Also attached to this inflated cost estimate was a 25-page skeleton argument, 5 pages of which were devoted to excusing away Buckle and Cotton as the patron saints of virtue they clearly are. The other 20 pages were devoted to smearing me. I kid you not, 20 A4 pages of muck shovelling and character assassination that must have taken them weeks to compile. I won't bore you with the details because I didn't bore myself with them either. I read the first 2 paragraphs and binned it. All I can say is that clearly the police don't like me very much. The aim of those 23 pages was of course to convince the judge that my prosecution was vexatious and therefore an abusive process. But fortunately, the judge refused to hear any of it and stated very early on, "I do not accept that this application is vexatious." But as well as authoring fiction about me, the police had fictionalised Cotton and Buckle as the true victims in all of this. Here's some of the lies that Staffordshire Police submitted to the court. The officers spoke to the boy to give him safety advice. The officers told him that he was not being detained. The complaint was recorded pursuant to the Police Reform Act. PC Cotton apologised for the over-assertive demeanour of the officers. PC Buckle was given management advice and her engagement with the public will be monitored. PC Cotton was also given management advice specifically in relation to dealing with juveniles. The original incident wasn't reported to the police. It was that last statement that I found the most incredulous of all. How much more could this incident be brought to the attention of the police when the incident involved the police, was seen by the police? I called the police, the victim's father called the police, I emailed the police, as did about 100 others, including the victim, and the police made excuses for it in a variety of press and social media releases. And even after all that, Staffordshire Police still refused to record it as an official complaint and attempted to dispose of it with an informal get-together consisting of 4 cops, the boy and his father. In fairness to the judge, he did allow me a full, uninterrupted 10 minutes to rebut all of this nonsense, but he clearly wasn't listening. His mind had been made up before he'd stepped foot in the court. That mind being, we cannot have the great unwashed criminalising agents of the state for public order offences. The judge then overstepped his judicial authority and mitigated the officer's offending as a case of robust policing. The purpose of the pre-summons hearing was to determine if prima facie the elements of the charged offences were made out. A first-year law student could have told him that was so. Staffordshire Police's barrister then dragged the hearing out for another half hour, refusing to leave until he'd succeeded in punishing me with an adverse costs order. When I asked the barrister to produce any regulations or case law that supported his argument that refusal of summons entitled him to costs, he fell silent. He then changed tact, insisting that I had abused process by not seeking permission from the CPS before commencing my prosecution. I asked him where in the Prosecution of Offences Act it stated permission must be sought from the CPS. Again, no response. I pointed out to the judge that if a private prosecution required permission by the state, it would no longer be a private prosecution, obviously. And furthermore, if refusal to issue summons by the court automatically held the prosecutor liable for costs, then it would seriously undermine the integrity of all private prosecutions. The upshot of it all was that Staffordshire Police had to pay their own deliberately inflated costs. I didn't get my summons, and Buckle and Cotton walked away from it scot-free. So the question is, am I going to appeal the decision? Not a chance. And it has nothing to do with Staffordshire Police's heavy-handed attack of me, nor the judge's obstinate refusal to stay within his jurisdiction. Unfortunately, it's due to the victim's misguided decision to meet with PC Cotton and his cadre of senior officers before the private prosecution commenced and without recording the meeting, something I explicitly advised him to do. I was given a brief account of what occurred at that meeting by the victim soon after, but what I didn't know is that he and his father had made some needless remarks at that meeting that Staffordshire Police were now exploiting to their full advantage. And the first I knew about it was when I read it in the skeleton argument the night before the hearing, a document that the police ensured I received at the last possible moment to give themselves the greatest tactical advantage. I cannot express enough how important it is that you never, ever talk to the police, especially when you have a pending complaint against them, least of all a criminal complaint. Now, I don't blame the victim or his father directly for this. They made the mistake most people would make, and that was to assume that those officers overseeing the complaint were genuine and sincere about their concerns. Police complaints are investigated for one reason alone: to limit damage wherever possible to the officer and the force, and the police will prey on the complainant's sense of decency every time. Anything you say in the spirit of friendly and open communication, any concessions you give or compassion you show will be exploited and misrepresented to your cost. In this case, both the teenager and his father's civility and the real judge comments at this informal police excuse party was the final nail in the coffin of this prosecution. Out of respect to the victim and his father, I won't repeat verbatim what they said, but The document presented to the court made it clear that the victim had all but forgiven the two officers concerned, that he did not believe the officers should be sacked, and the victim even conceded that now he'd met one of the officers, despite Lauren Buckle refusing to attend, he accepted that he was a nice bloke and maybe they could draw a line under the matter. Now, I don't believe for one moment that the account presented to the court is anything other than an exaggerated and doctored version of what was really said, but I do believe that the victim made some unfortunate concessions in the spirit of cooperation. But without any recording to prove what was said, it would be his and his father's word against 4 police officers. Why else do you think they brought so many officers to an informal meeting? So that their word would always outweigh that of the complainants. I don't know what influence, if any, this had on the judge. At the hearing, I asked him to disregard it as hearsay. I also suggested that if he was to base any part of his decision to deny summons on what was said at that meeting, then the hearing should be adjourned so that everyone who was there could give evidence. But already I knew that this had crippled the prosecution. Even if I'd been granted a summons, the CPS would have taken it over, dropped the prosecution on the basis of that meeting, thereby negating the purpose of me pursuing it in the first place. Now, as I say, I accept that it was a foolish mistake on the part of the victim and his father, especially knowing how manipulative the police are when it comes to getting rid of complaints. But I can't be expected to put myself on the line, fighting in the lower courts and then the appeal courts, exposing myself to excessive costs when the people I'm helping opt for social nicety over a determined resilience. My policy has always been to help people as much as they're willing to help themselves, and it would be ridiculous to expect me to extend my neck far across the chopping block when others so quickly tuck theirs back in. It's a shame because the court's refusal to issue summons against a police officer for public order offences committed on duty needs to be fully tested in the appeal courts. But for the reasons I've already stated, this won't be that case. But believe me, this is by no means the last private prosecution I'll be bringing, but for now, I'll be pursuing the more egregious cases of police criminality and violence, such as these 3 delightful specimens who broke a driver's knee in their bid to arrest him for a housing benefit overpayment. 2 of those officers went on to fulfil the ambition that so many officers yearn for these days, and that was to sexually abuse and rape vulnerable women and children. Right now, Nicholas Musto is where he deserves to be, in jail. Ben Stacey is still working for the police in CID, but where is Leigh Brightman? He was imprisoned in 2015 for child sex offences and has subsequently been released. He then changed his identity and absorbed himself, like shit in a field, into the general population. I received a tip-off a few months ago as to where Leigh Brightman is now working and living, so that way I could send him his charge sheet for GBH. To my total horror, it turns out that he's obtained work in a flour mill, right next to a children's nursery. I rang that particular flour mill and asked them if they knew that they had an ex-paedophile police officer working for them. It became clear to me very quickly that not only did they know, they were willing to cover for him. It turns out that he has a very rich mummy and daddy that he stands to inherit a fortune from and part of their estate when they die. An estate which happens to be just a few streets away from his employ. I'm guessing that mummy and daddy must have pulled a few strings to secure gainful employment for their delinquent son as penance for his heinous crimes. I fail to see what use this job is to a soon-to-be millionaire sexual predator, unless he's actually climbing into the ovens when they're on. Perhaps it was being situated so close to a nursery school that tipped the scales for him. Well, let's just hope that nobody drops a file containing the truth of his past deeds onto anyone that needs to know in that area. At the very least, the local police station where he should be attending regularly as an ongoing requirement of being on the sex offenders register.